Imagine a scenario where law enforcement officers show up at your doorstep, demanding entry into your home without a warrant. How would you react? Today we're going to delve into the Fourth Amendment, exploring the crucial legal protections it provides against unreasonable searches and seizures and the impact it has on our daily lives. At its heart, the Fourth Amendment is an effort to balance an implicit right to privacy against the desire for security in a democratic society. Privacy rights are fundamental to human dignity and personal autonomy. They encompass the ability to control personal information, make choices free from unwarranted government intrusion, and maintain a sense of security within one's personal spaces and effects. Privacy is essentially for fostering personal development, maintaining intimate relationships, and enhancing and engaging activities without fear of unwarranted surveillance or interference. The Fourth Amendment, as part of the Bill of Rights, addresses the issue of unreasonable searches and seizures by the government. The historical roots of the Fourth Amendment can be found most clearly in the English common law tradition. In 1604, British jurists in the Semaine case ruled that the state's authority was not unlimited, particularly in the private dwelling of its subjects, but that warrants should be required before conducting searches or seizures. In that case, Sir Edward Coke famously asserted that the house of everyone is to him as his castle and fortress, and well for his defense against injury and violence as for his repose, a saying we more commonly know as a man's home is his castle. Much to the consternation of the colonists, homes in colonial America did not enjoy the same sanctity as their British counterparts, in large part because legislation had been written to enable the enforcement of tax collection by British authorities. Indeed, in 1750, only general warrants, sometimes referred to as writs of assistance, were issued in the colonies, permitting authorities in possession of such warrants almost unfettered power to search anyone, anywhere, for anything at any time. Such warrants were widely unpopular among the colonists, with Massachusetts lawyer James Otis leading a legal charge against them. John Adams, who was present for some of Otis's court proceedings, described the use of general warrants as the spark which originated the American Revolution. Perhaps not surprisingly, the majority of state constitutions after the Revolution included provisions limiting or prohibiting the use of general warrants. The Virginia Declaration of Rights of 1776, for example, expressly forbade the use of general warrants, providing that general warrants whereby any officer or messenger may be commanded to search suspected places without evidence of facts committed, or to seize any person or persons not named, or whose offense is not particularly described and supported by evidence, are grievous and oppressive and ought not to be granted. Similarly, Article 14 of the Massachusetts Declaration of Rights of 1780 noted that every subject has the right to be secure from all unreasonable searches and seizures of his person, house, papers, and his possessions. All warrants, therefore, are contrary to this right if the cause or foundation of them not previously supported by oath or affirmation, and if the order in the warrant to a civil officer to make search in suspected places or to arrest one or more suspected persons or to seize their property be not accompanied by a special designation of the persons or objects of the search, arrest, or seizure, and no warrant ought to be issued but in cases and with the formalities prescribed by the laws. And if we look more closely at the text of the Fourth Amendment, we see how it draws directly on these precedents. The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Analyzing the text of the Fourth Amendment a bit more closely, we can identify several important elements that shape its interpretation and application. The amendment begins by establishing the right of the people, emphasizing its individual nature. This reflects the broader understanding that individual rights are fundamental and should be protected from government intrusion. But it's also a broad right, protecting against government intrusion into our physical bodies, dwellings, and personal possessions, reflecting the importance of privacy across various aspects of life. The primary protection afforded by the Fourth Amendment is the prohibition against searches and seizures that are deemed unreasonable. In other words, it places limits on the government's authority to intrude into individuals' lives and restricts the power of law enforcement to conduct searches or confiscate property without just cause. And in doing so, it emphasizes the fundamental nature of the right to be secure against unreasonable searches and seizures, emphasizing a strong presumption in favor of protecting individual privacy and limiting government actions that infringe upon this right. And finally, the Fourth Amendment requires that warrants which authorize searches or seizures must be issued by a judge or magistrate only when there's probable cause, meaning that there must be a reasonable belief based on facts and circumstances that a crime has been committed or that evidence of a crime will be found in the place searched or the items seized. Without such consideration, the government may not issue such a warrant. The Fourth Amendment is rooted in the idea that people should have a reasonable expectation of privacy, which in turn helps determine the extent to which they're protected against unreasonable searches and seizure by the government. It refers to an individual's objectively justifiable belief that certain spaces, activities, or information are private and shielded from government intrusion. Or think of it like this. Imagine you're having a conversation with a friend. We might expect that conversations had at home are private. We have a reasonable expectation of privacy in that situation. To listen in on this conversation, the state would normally need to obtain a warrant and provide a clear justification for that warrant to the courts. But that same conversation in a crowded coffee shop might not be entitled to the same protection or expectation of privacy, as anyone nearby might overhear parts of the conversation. In that context, the state could likely listen in on the conversation without first obtaining a warrant. In its decision in Katz v. United States, the United States Supreme Court concluded that a reasonable expectation of privacy exists when two conditions are met. First, the individual must exhibit an actual expectation of privacy in the place, activity, or information being considered, usually referred to as a subjective expectation of privacy. This expectation may be demonstrated through actions, statements, or the circumstances of the situation. For example, if an individual closes the door to their hotel room or shuts the blinds in their home and believes their conversation inside is private, they're expressing a subjective expectation of privacy in that space. Similarly, when someone enters a password into a protected online account, they're indicating a subjective expectation that their digital communications are private. However, the subjective expectation alone is not sufficient to establish Fourth Amendment protections. It must also meet the objective reasonableness standard, which assesses whether the subjective expectation of privacy is objectively reasonable by societal standards. It focuses on whether society recognizes the expectation as reasonable regardless of the individual person's beliefs. The test considers how a typical or reasonable person would view the situation and whether their expectation of privacy aligns with the individual's subjective expectation. For example, an individual speaking in hushed tones in a public park may subjectively believe their conversation is private. However, the objective reasonableness standard may not recognize this expectation as reasonable because parks are generally considered public spaces where conversations can be overheard. Similarly, if a person leaves their garbage bags on the curb for collection, they may subjectively expect the contents to remain private. However, the objective reasonableness standard may not recognize this expectation as reasonable because discarded garbage is generally considered abandoned and accessible to the public. In assessing the objective reasonableness of an expectation of privacy, courts consider societal norms, customs, and common understandings. They analyze whether society recognizes generally the expectation as legitimate and deserving of Fourth Amendment protection. It's important to note that the subjective expectation and objective reasonableness standards are interconnected. While the subjective expectation establishes an individual's personal belief, the objective reasonableness requirement ensures that that expectation aligns with societal norms and reasonable expectations of privacy. Courts apply these standards to various scenarios, such as surveillance of phone conversations, searches of electronic devices, GPS tracking, drug testing, the use of thermal imaging, and more. The specific facts and circumstances of each case are evaluated to determine whether a reasonable expectation of privacy exists, ultimately shaping the boundaries of Fourth Amendment protections. The second key component of the Fourth Amendment focuses on the idea of probable cause. But what exactly is probable cause? The term itself is found in the text of the Fourth Amendment, which mandates that no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Despite this, there's no universally accepted definition of the concept. One common definition of the concept of probable cause is found in the U.S. Supreme Court's decision in the case of Beck v. Ohio, in which the court said that probable cause exists when, at the moment of arrest, the facts and circumstances within an officer's knowledge and of which they had reasonably trustworthy information are sufficient to warrant a prudent person in believing that a suspect had committed or was committing an offense. In other words, probable cause exists when there is reasonable belief that a crime has been committed or that the evidence of a crime will be found in a particular place or on a particular person. It requires more than mere suspicion or a hunch, but it falls short of the certainty required for conviction. It's an objective standard based on facts and circumstances that would lead a reasonable person to believe that the search or seizure is justified. To establish probable cause, law enforcement officials must present sufficient evidence to a judge or magistrate that supports the belief that a crime has been committed or that there is evidence of a crime. The evidence may include witness statements, physical evidence, surveillance, informant tips, or other reliable sources of information. The requirement of probable cause serves several purposes within the Fourth Amendment framework. It acts as a safeguard against arbitrary or unfounded searches or seizures, ensuring that law enforcement actions are based on reasonable grounds. It helps maintain the balance between individual privacy rights and the legitimate interests of law enforcement in investigating and preventing crime. But it's important to note that there are a number of exceptions to the requirement that police obtain a warrant based on probable cause to search an individual or their property. The existence of exigent circumstances can mitigate the need for a warrant. Exigent circumstances refer to situations when the conditions require urgent or immediate action to prevent imminent danger. This might include situations where there's a risk of harm to individuals, there's a likelihood that evidence would be destroyed, or in the pursuit of a fleeing suspect. For example, if law enforcement receives report of an active shooter inside a public building, they may enter that building and conduct a search without a warrant to address the immediate threat and ensure the safety of individuals present. Probable cause is also not required when making lawful arrests. In conjunction with an arrest, law enforcement officers are permitted to conduct a warrantless search of the arrested individual and the immediate surrounding area. This is done to ensure officer safety, to prevent the destruction of evidence, and to locate any weapons or threats that may be posed. If an individual voluntarily consents to a search without coercion or duress, law enforcement may conduct a search without a warrant. Such consent must be given freely and knowingly by someone with the authority to give consent. For example, if a homeowner voluntarily allows law enforcement to search their residence during an investigation, the officers may proceed with the search without a warrant as long as the consent is freely and knowingly given. The plain view doctrine permits law enforcement officers, if they are lawfully present in a location and come across evidence or contraband that is immediately apparent and in plain view, to seize that evidence. For example, if while on a routine patrol, an officer notices drug paraphernalia in plain view in the back seat of a parked car, the officer may seize the evidence without a warrant as it's immediately apparent and in plain view. Due to the inherent mobility of vehicles and the reduced expectation of privacy associated with them, there is an exemption to the warrant requirement for searches of motor vehicles. Law enforcement may conduct a warrantless search of a vehicle if they have probable cause to believe that it contains contraband or evidence of a crime. For example, if an officer has probable cause to believe the vehicle is transporting illicit drugs, they may conduct a warrantless search of the vehicle to locate and seize the contraband as long as the search is conducted within the scope of probable cause. At the international border or airports, where the government has an interest in regulating the flow of people and goods, searches are also given more leeway. Routine searches of individuals and their belongings at border crossings and airports can be conducted without a warrant or a probable cause. The courts have ruled that this exemption applies at all border crossing points regardless of the distance from the physical border and also includes anyone within 100 miles of the border. Law enforcement may conduct warrantless searches of personal property, such as impounded vehicles or items held in police custody, to create an inventory and protect against claims of lost or stolen property. These are often referred to as inventory searches. And finally, there is a school search exemption to the requirement for a warrant, permitting school officials or police to search students and their belongings without a warrant and based only on a reasonable suspicion that the individual may be in violation of school rules or of the law. In general, these exceptions reflect the recognition that certain circumstances may require immediate action or present diminished expectations of privacy. However, they are subject to scrutiny and must still meet certain constitutional standards, such as reasonableness and adherence to the specific requirements outlined by the courts. It's also important to note that the courts have established higher and lower standards related to probable cause. These standards allow law enforcement to conduct searches and seizures in specific scenarios where probable cause may not be required. Some of these standards include the idea of reasonable suspicion, which is a lower standard than probable cause and is often used for temporary detentions or investigative stops. It requires specific and articulable facts that lead a reasonable officer to believe that criminal activity may be occurring. Reasonable suspicion is commonly used in so-called Terry stops, named for the Supreme Court's decision in the case of Terry v. Ohio. During a Terry stop, law enforcement may briefly detain individuals for questioning based on reasonable suspicion of criminal activity, and may even frisk stopped persons for the purpose of officer safety. The standard of administrative probable cause is used in certain administrative contexts, such as administrative inspections or regulatory compliance, when a lower standard of probable cause may be sufficient. This standard requires a reasonable belief that a violation of the administrative regulation or requirement has occurred. An example of this might be when inspectors from a regulatory agency visit a restaurant to conduct a routine inspection for health and safety compliance. The inspectors have administrative probable cause to conduct the inspection based on the reasonable belief that the establishment must comply with specific regulations regarding food handling, cleanliness, and overall safety. School searches of students are justified in the same way. Some jurisdictions allow for a lower standard called reasonable articulable suspicion. It is similar to reasonable suspicion, but requires the officer provide some specific fact or articulate the reasons for suspecting criminal activity. For example, a security guard at a shopping mall might observe a person pacing back and forth near the store's entrance, periodically glancing inside their backpack. The guard notices these suspicious behaviors and approaches the individual for further questioning based on the reasonable articulable suspicion that they may be planning theft or other criminal activity. In some situations, the courts may apply a more flexible standard known as the totality of circumstances. This standard uses all relevant facts and circumstances to determine if search and seizure is reasonable based on the Fourth Amendment, even if probable cause is not met. It allows for a broader analysis that takes into account the specific context and balancing individual privacy rights against law enforcement interests. For example, in a drug trafficking investigation, law enforcement officers might receive an anonymous tip about a particular individual who is allegedly involved in drug distribution. The officers conduct surveillance, monitor the individual's activities, gather information, and consider the totality of the circumstances to establish a reasonable suspicion or probable cause to proceed with a search warrant or an arrest. And finally, as we've noted before, consent may provide another basis for conducting a search or seizure without probable cause. If an individual voluntarily gives their consent, law enforcement may proceed with a search even without meeting the probable cause standard. It's important that the consent is given freely and knowingly without coercion or duress. The primary mechanism through which the Fourth Amendment protections are enforced is known as the exclusionary rule. The exclusionary rule holds that evidence obtained as a result of an unlawful search in violation of the Fourth Amendment is generally inadmissible in criminal proceedings. This means that if the government obtains evidence through an unconstitutional search or seizure, that evidence generally cannot be used against the accused in a court of law. The purpose of the exclusionary rule is twofold. First, by excluding evidence obtained through Fourth Amendment violations, the exclusionary rule discourages law enforcement officers from engaging in unconstitutional searches and seizures. It serves as a deterrent, encouraging officers to obtain valid search warrants and respect individuals' privacy rights. And second, the exclusionary rule ensures the integrity of the judicial process by preventing the admission of evidence obtained unlawfully. It maintains the credibility and fairness of the justice system by disallowing evidence that was obtained through violations of constitutional rights. That said, the exclusionary rule is not an absolute rule, and several exemptions and limitations exist. If law enforcement officers reasonably believe their actions were lawful based on a warrant issued by a judge, even if that warrant is later found to be defective, the evidence obtained may still be admissible. This is known as the good faith exception, and it allows for the admission of evidence even if it was obtained through an unconstitutional search and seizure, but the law enforcement officers acted in good faith based on a defective warrant. The inevitable discovery doctrine allows for the admission of evidence that would have been discovered through lawful means independent of the unconstitutional search and seizure. For example, say during an illegal search of a suspect's home, an officer finds evidence of a crime. If the prosecution can establish that the evidence would have been inevitably discovered by a lawful means, say through execution of a valid search warrant based on independent information, regardless of the initial unconstitutional search or seizure, the evidence may be deemed admissible. The independent source doctrine allows for the admission of otherwise unadmissible evidence if it was obtained through an independent lawful source unrelated to the initial unconstitutional conduct. Say law enforcement receives a tip from an anonymous informant about a drug operation. Acting on this information, the officers conduct an illegal search of the suspect's property and find incriminating evidence, resulting in the exclusion of that evidence. If later in the investigation, law enforcement officials obtain a valid search warrant based on information gathered independently from the initial unconstitutional search, the evidence discovered through the subsequent lawful search is considered separate and unrelated to the initial search and may therefore be admissible under the independent source doctrine. Finally, the attenuation doctrine applies when the connection between the unconstitutional search and seizure and the discovery of evidence becomes sufficiently remote or attenuated, rendering the evidence admissible. For example, if a suspect were unlawfully arrested without probable cause, but subsequently makes a voluntary confession while in police custody, the confession may be considered admissible if the court determines that the connection between the illegal arrest and the confession is sufficiently attenuated. Factors such as the passage of time, intervening events, or the voluntary nature of the confession can be considered in assessing attenuation. It's worth noting that the application and scope of the exclusionary rule have been subject to ongoing debates and modification by the courts. Some argue that the rule can hinder the pursuit of justice by potentially allowing guilty individuals to escape punishment due to technical violations. Others maintain that the exclusionary rule is essential for protecting individual rights and maintaining the integrity of the criminal justice system. The scope and application of the Fourth Amendment protections are constantly evolving, and a variety of new technologies from artificial intelligence and computer algorithms that might help predict criminal activity, to eavesdropping on and tracking wireless communications, to the massive spread of surveillance cameras, to the collection of vast amounts of digital and genetic information, all raise questions about the future scope and nature of the Fourth Amendment. But that's it for now. Please leave any questions you have in the comments section below, and thanks for watching.